Mr. Baldry.
My Lords, we do have copies of the auto logic case, and I was, if I can hand up copies, it won't take long. Just to recall that this was referred to by Lord Newberger at paragraph 79E in support of the proposition that insofar as legislature introduces a retrospective time limit without reasonable transitional provision, the national courts can't enforce the retrospective time limit in relation to accrued right, at least for a reasonable period.
Yep.
Otherwise, there will be a breach of community law. Now, auto logic was not a limitation case, but the Lord Newberger has cited it as a proposition for a more general proposition of the relationship between EU law and UK law, which is effectively being applied to time limits.
Yes.
So paragraph 16 and 17 of auto logic, this was the issue in the case was what's the appropriate jurisdiction for community-based claims to be progressed. Was it the High Court or was it the Commissioners? And the point being made is, well, the Commissioners are entitled to apply EU law rights just as much as any other court, and in particular the rights concerning the availability of group relief, which had previously been found to be inconsistent with EU law, so that there needs to be some form of disapplication or moulding of the domestic provisions to make them comply. But it raises the point raised by my lord concerning what's the constitutional relationship between community law and UK law, paragraph 16, and the reference to section 2 of the European Communities Act, the basic task which we're always engaged on in these cases is that where there is an inconsistency with EU law, the domestic provision is to be read and to take effect as though the statute enacted that the offending provision was to be read without prejudice to the directly enforceable rights of persons having the benefit of such rights. So that doesn't entail necessarily the section being read out completely, and in the context of the provisions that they were dealing with, namely whether the group relief provisions could be read in a way that was compatible with EU law. Lord Nichols confirms that, if the matter were to go to the Special Commissioners on a statutory appeal, their position as a national court is the same as in Simmental. So accordingly, below B, if an inconsistency with directly enforceable community law exists, formal statutory requirements must, where necessary, be disapplied or moulded to the extent needed to enable those requirements to be applied in a manner consistent with community.
The case of ICI and Colmer, to which Lord Nichols refers at the end of paragraph 16, was just such a case.
Yes, that was the consort group relief provisions where I think the House of Lords made it clear, well, the Court of Justice made it clear that insofar as the provisions were within the scope of EU law, then you applied EU law, and insofar as they weren't.
So the taxpayer company, in fact, failed. That's why it's called number 2. Because it had gone to Luxembourg, it then came back, and in the light of the answers given by the Court of Justice, the House of Lords held you lose.
Yes.
Because actually your facts don't fall within the scope of community law.
Yeah.
And so the legislation remained valid and extant in your case, no matter that it might infringe the rights of some other company who was able to take advantage of directly effective community law rights.
Yes. Yes, the group relief. You looked at the group relief provisions, and they were incompatible with EU law in certain respects, but insofar as they weren't, you applied them.
So it does lead to the end result. You can have the self-same statutory wording in a provision which has different meanings depending on the parties to whom it is applied. I mean, which is a difficult proposition to get one's head around,
Yes,
but it's implicit in this whole system.
Yes, certainly different effect. I mean, with the disapplication, it means what it says, and it just ought to be applied. But with the conforming construction, then yes, it is possible. That,
Yes.
It shifts.
When Lord Nichols says disapplied or moulded, is the moulding a reference to conforming construction only?
That's how I read that.
I
yes.
see, yes. Yeah.
So essentially, the same task is to be applied when one's looking at the limitation periods and the extent to which they are compatible with EU law.
Does Lord Walker say anything about this?
I'll take you to Lord Walker. He was very clear that the process that was being engaged in this case was one of disapplication.
Right.
Paragraph 24 of the decision on page 51. And he considered that the court below had rather overlooked the distinction between conforming construction and disapplication.
So did you say paragraph 24?
Paragraph 24 is the beginning of Lord Walker's.
Sorry, we're back in Fleming.
You're back in
Fleming. Oh, yeah.
Yeah, your question was about what
I thought
Lord
you
Walker
moved
has
on
to
to-
say in orthologic.
It's my fault. Don't take time now.
No, I
but,
don't recall.
but if Lord Walker says anything about this general question, I'd certainly be grateful to be reminded of that.
I have a vague recollection he does, but I might get one
Yeah.
wrong and
That's
confuse it with a different case.
Paragraph 91, he certainly talks about its effectiveness.
Yeah.
I think he at some point deals with the more general question.
89 is where he talks about
Yeah.
European community.
Please don't take time on it now, but if somebody can help us in due course.
We will do. So that was all I was proposing to say on auto logic.
Thank you.
So if we can go back to Fleming, Authority of Bundle 1, tab 2. I've taken you to the sort of summary of the principles that Lord Neuberger had been through at paragraph 79. He then, at paragraph 80, he rightly says that the aspects in issue in relation to the revenues arguments in Fleming revolved around H and J. And the point that he raises at paragraph 80 is whether it is open to the court to disapply the retrospective limitation for a limited period as opposed to permanently in cases where the legislation imposing a retrospective time limit contains no transitional period, as in the present case and in Marks and Spencer. And he noted in the Court of Appeal in Fleming, the court had considered that paragraph 41 of Grundig only applies where there is an inadequate transitional period. I think that's the point raised this morning.
Yes.
And Lord Neuberger disagrees with that approach at 81 G. He says that the question in Marks and Spencer's was admittedly widely expressed, that the ECJ held that such a time limit was incompatible with the principles of effectiveness. However, nothing was said either way as to whether the unlawfulness of not providing a transitional period was, as it were, permanently fatal to the efficacy of the retrospective time limit. That was a topic on which the court did express a view, albeit not strictly arise from the specific question referred in Grundig 2 at paragraph 41. As I understand it, the ECJ was there seeking to give guidance to tax authorities, courts and taxpayers in member states as practical consequences where retrospective time limits were imposed without adequate transitional provisions. At least for present purposes, I can see no difference in principle and practice in a case where there is an inadequate transitional period and one where there is no transitional period. In each case, there is no adequate transitional period, to use the ECJ's words in paragraph 42 of Grundig 2. I think accepting that it's open to the court to disapply retrospective limitation for a limited period as opposed to permanently. And the question was, in the circumstances of Fleming, should the court do so as the revenue were inviting them to do so? And as I explained this morning earlier, what the revenue was seeking to do was to introduce get the court to read in a transitional period which had the effect of applying across the board to taxpayers who'd had a right to repayment, which had been taken away by the introduction of regulation 29(1)A, but that could be done because the court could simply read in an appropriate period of disapplication. So there was no distinction being drawn in the revenues case in the House of Lords in Fleming between those persons who'd had their rights removed in a puff of smoke and those who may have an adequate period of time following the introduction of the new rule in which to make their claim. And they put in, there is guidance given by Lord Neuberger as to what a reasonable period might be at paragraph 84. It says, the 84, he recalls the Commissioner's primary case that the appropriate period of disapplication should be equivalent to the transitional period which the legislature ought to have accorded under community law but failed to do so. That seems to me to be a surprising proposition. On the basis of the limited argument and evidence you've received on the point, it appears to me that the duration of a transitional period required in the present case to satisfy community law would have been between 6 and 12 months. 6 months was the minimum period thought by the ECJ to be appropriate in Grundig 2, where a time limit retrospectively reduced from 5 or 10 years to 3 years. At the other extreme, albeit without the benefit of detailed argument, I find it hard to conceive of circumstances which would require a transitional period of more than a year, at least where a time limit is retrospectively created or reduced in relation to commercial tax claims. On that basis, given that Regulation 29(1)A came into force on 1st of May 1997, people with accrued rights to claim input tax as at that date would have had to put their claims in by 1st of May 1998 at the latest. So one reaches this position. This was the effect of the revenues argument. The vice in the regulation is that it contains no transitional period to enable persons with accrued rights to make their claims. And as we've seen from the case law of the court, It's to enable persons whose rights are taken away by the new legislation to bring the claims that they could have brought. The remedy on the Commissioner's case is that there is to be a period of disapplication whose existence would be unknown to any reasonably well-advised person with an accrued right until it had already expired. That would mean that the supposed remedy for the failure to accord a transitional provision would be a little more than hypothetical. In other words, from the perspective of community law, I consider the Commissioner's solution to the problem fails on the very ground that the problem exists, namely that it breaches the principles of effectiveness and legitimate expectation. 1 year of disapplication expiring in May 1998 would come to an end before, indeed years before it was established that there had been an absence of a transitional provision, meant that there had been a breach of community law, albeit that there was nonetheless the possibility of a period of disapplication, and also in this case, contrary to the firmly expressed opinion of the Commissioners that the claims fell within Regulation 29. So that led to the conclusion the law considered that the revenues case would involve hardly more than paying lip service to the important principles of effectiveness and legitimate expectation. And one can see why it is simply paying lip service to the principles, because if you do retrospectively remove someone's right to make a claim for tax, so that they, on the face of it, they have no claim, they're out of time, then you can't, by an act of the court, retrospectively read in a period of disapplication, because it's that period of disapplication that gives rise to the new time limit by which they've got to act, and they don't know it's there. So he said that even applying Grundig 87, even applying Grundig 2, you can't conclude that a length of disapplication period would be 6 months, and that's right, because Grundig 2 was accepting paragraph 41 that you do have to disapply it insofar, disapply the national provision insofar as it offends, insofar it's necessary to do so to prevent the legislation offending the principle of effectiveness, and the court had explained what was necessary to comply with the principle of effectiveness. Likewise, at paragraph 88, another problem with the revenues case is that if you are applying this transitional period to someone who's had their rights taken away from them, so they wake up when the new legislation has been passed and they don't have a time limit, then the effect of reading in this time limit would breach the condition that the limitation period has to be fixed in advance, because it only comes to an existence by the declaration of the court declaring what the transitional period is. So again, that's a further reason for rejecting the revenues argument. But all these points arise out of the revenues position in Fleming, that one can apply this ex post facto transitional provision in the case of someone whose rights have been taken away. And in that context, he says at paragraph 90, I cannot accept that the adequate transitional period referred to in paragraph 41 of Grundig was intended to be one identified on an ad hoc basis to be applied retrospectively from the start, the date the new limitation period came into force, let alone to start and even end in circumstances where the great majority of those who were intended to benefit from it, i.e. persons who've had their rights taken away and put in an impossible position, would reasonably be unaware of its existence. Such an interpretation would be quite inconsistent with much of the thrust of the reasoning on the ECJ on the issue before it, in my opinion, the last sentence of paragraph 41, that paragraph of Grundig 2, the court was saying that legislation containing a retrospective limitation period without a transitional provision could be retrospectively effective, provided that what amounted to an effective transitional period, such as a period of disapplication, was accorded by the member state, but it was for the member state to determine how and when it accorded such a period, and what the period was, provided community law principles, especially those of effectiveness, etc., were satisfied. So again, in the context of a limitation period that's being applied in the situation where community law has said it's necessary for there to be a transitional period, then that's for the member state to do. But that's not the exercise in this case. In this case, we're seeking to apply the limitation period which has been introduced and fixed in advance by Parliament by Section 320 as against taxpayers who were aware of that and who had a reasonable time to bring their claims within that new limitation period. But Lord Neuberger certainly does not sort of rule out in all cases that a period of disapplication can be made. He says at paragraph 108 of his decision that he's prepared to accept that in an appropriate case a decision of the United Kingdom Court could have the effect of commencing a period of disapplication. And where in my submission it can and should have that effect is where you have a situation of that we have here of the new time limit being introduced and being applied to a taxpayer who has ample time, 3 years in Jazztel's case, in which to bring their claims under the newly introduced time limit. So that's Lord Neuberger. Lord Hope also said that paragraph 10 of his speech on page 46 of the bundle, he essentially agreed with Lord Neuberger, but at paragraph 10 he said, "I would not rule out the possibility in a suitable case of the court reaching its own decision as to what would be a reasonable time for the making of claims and rejecting claims that were made after a period which was held to be reasonable. But I do not think that the situation disclosed by these appeals lends itself to that treatment."
Can you just read on the next couple of sentences?
In my opinion, this is a step too far for the court to take. The issue is not one of statutory interpretation for which the court must accept responsibility. There's a gap in the legislation which is unfilled. The infringement of EU law in this respect cannot be said to be comparatively minor or inadvertent. Now, in the present case, with the guidance of the Court of Justice, which accepts that the National Court can apply a transitional period which has been introduced, even if it doesn't have an adequate transitional period, then in my submission, that is not a situation as was the situation disclosed by the appeals in Fleming or Condé Nast. So the reasoning of this case has got to be understood in the context of the argument that was being presented to the House of Lords, but it doesn't in any way undermine the distinction that's being drawn by the European Court in Marks and Spencer's and in Grundig. Again, if in doubt, one falls back on what the principle of effectiveness is to determine whether the application of the legislation in Jazztel's case offends that principle. say it doesn't. So that's Lord Scott, just to complete it, Lord Carswell agreed with Lord Newberger. Lord Scott agreed that was very sort of firm that the court shouldn't, wasn't the court's role to fill in the gaps at all. Lord Walker was clear in drawing the distinction between disapplication and conforming construction, which he does at paragraph 24 of his judgment. So that's sort of picking up the auto logic point, 25.
This is actually the passage I recalled, and I've forgotten which case it was, but this is the one.
This is the one. Although he ended up being in the minority as far as the Condé Nast decision was concerned, but it is taken as being one of the main statements of principle on this application. So when it came to the disapplication in this case, he was clear that it was the duty of the National Court to disapply. That's at paragraph 62. Is the definition of an adequate transitional period properly a matter for the National Court, not for the legislature? In my opinion, that task is not merely within your Lordship's power, but is your Lordship's plain duty under EU law. The disapplication of offending legislation is the duty of the National Court, even if it involves action which would not otherwise be alien to the strong judicial instinct not to intrude on the province of the legislature. So I don't think anyone disagrees with that proposition, but the question is, how far do you disapply? And we say you must the court must disapply, but only insofar as the legislation offends EU law. So one can understand why in Fleming and Condé Nast the revenues argument failed, but it does not follow that the argument in this case is precluded by the reasoning of Fleming. We say that the argument in this case is positively supported by the case law of the Court of Justice. Those are the sort of authorities that are the relevant ones, we say, to apply when looking at the judge's decision. So what's the effect in Jazztel's case? Even on the assumption that Jazztel had not discovered its mistake until the decision in the HSBC case in 2009. On that assumption, Section 320 would have had the effect of curtailing the limitation period available to Jazztel from that applicable under Section 32(1)(c) 2 to 6 years from the date of payment. Even on that assumption, we say that the application of Section 320 does not offend the principle of effectiveness. Jazztel had an adequate period, prospective period, of 3 years in relation to its earliest payment in which to bring its claims. And so if we're right on that, then the effect is that Section 32(1)(c) doesn't apply, and I'll come to it later, but that means strictly that the court doesn't need to answer the question of discoverability in the present case, although it's a relevant step in looking at considering the judge's conclusions on Section 320 as a whole.
That is the logical way round, is it?
Not exactly. I mean, it could be either the logical way of me starting with Section 320 is because that is.
No, I quite followed that.
Yeah.
But in terms of the ultimate decision, do you decide first whether Section 320 applies, or do you decide first whether Section 32 applies?
Yes, you could do it either way, but the effect of Section 320 applying on the way I'm advancing the case is that even assuming that 32(1)(c) has provided an extended limitation period, even on that assumption, Section 320 should not be disapplied, and therefore the Section 32(1)(c) issue doesn't arise. But it is possible that your lordships would think, well, I want to know before part of the analysis will be, is the limitation period curtailed? If you consider that's an important step in the reasoning, if it is curtailed, then Section 320 might be incompatible with EU law, but not otherwise, then I suppose logically you would have to look at Section 32(1)(c) first.
Yeah.
Although I've taken to the EU authorities, you would have seen that there is a decision of the Chancellor who reached a different conclusion to the judge in this case. It came after Jazztel in Class 8. It's a decision in one of those GLOs where the points are quite sort of buried deep within the procedural interstices of that case. But I'll try and explain what the issue was there. That's Authorities Bundle 1, tab 6.
Has there been an appeal in that case to this court?
I would.
It's stayed away.
It's stayed, isn't it?
Yeah.
That stayed pending this decision. So, well, the reason I ask is that depending on the submissions we hear, it may be that we will have to decide in the present appeal which of these two judgments is correctly decided. So, is that right on your submission?
Yes.
They can't both be right, is that right?
It's difficult to see how they could both be right.
So in one sense, well, I don't know.
Yeah.
I don't want to put words into anyone's mouth. I just want to understand what the task is that we're facing. 'Cause in one sense, we're being asked to say the Chancellor was wrong.
Yes.
In that case, I mean, Mr. Grudzinski expressly says that in his skeleton.
Yes, absolutely. Yes, on the section.
Yeah. So even though we're not hearing an appeal from the Chancellor in that case, we may have to say whether he was right or wrong.
Yes, you'll have to take a decision. And as you've seen, the fundamental difference of approach taken there is on the sort of concept of knowledge.
Yes.
So can I just explain the background to this case? Because the point arose, which is of concern in this case, and the relevance of hidden retrospectivity in affected by legislation. Actually, it arose, and the argument was given in relation not to a limitation period, but to an ouster clause, but essentially it had the same effect. And as well as that part of the decision, the Chancellor also turns to section 320 briefly at the end of his decision, and reaches, again, a decision which is inconsistent with that of the judge in the present case. This is a case which Sir Launcelot Henderson will know the background to and be familiar with the underlying issues, but
well, I was at one stage. Whether I remember all the ins and outs of all these cases is another matter.
The CFC and dividend GLO covers another one of the GLOs in the sort of constellation of tax GLOs. This litigation covers common law claims in mistake for the recovery of overpaid corporation tax on dividends received by investors who had portfolio investments in UK and overseas companies. So small shareholdings, less than 10%. Under the UK imputation system, the UK granted an exemption for dividends from UK portfolio shareholding. So if you held a small percentage of shares in a UK company, you were exempt from tax on your dividends, but the UK charged tax, corporation tax, on companies who received dividends from overseas companies where the shareholding was less than 10%. And as part of that regime, the United Kingdom gave a form of double taxation relief, under which it gave shareholders, certain shareholders, credit for the foreign tax paid by the companies which had paid them dividends. So if you were a non-portfolio shareholder, typically companies within groups, you were entitled to a form of tax credit for the tax paid by the foreign company to ensure that the profits weren't being taxed twice. But portfolio shareholders didn't benefit from that form of double tax relief. The UK statute said that if you had less than 10%, you didn't get a tax credit for your overseas dividends. It took many years of litigation to determine whether that treatment was compatible with EU law, and if not, what the remedy should be. And this litigation was also going on at the same time as the franked investment income litigation, which was deciding similar issues. But ultimately, before we get to the Class 8 claimants, the European Court of Justice confirmed that in taxing portfolio dividends without providing an appropriate credit, the UK legislation was incompatible with EU law. That was about 8 years ago now. The effect of that decision in the Court of Justice was that the claims in the CFC litigation began in the High Court, and the test claim was a case called Prudential, which came before Mr. Justice Henderson. And in that decision, it was held that it was possible to interpret the UK regime to enable by a conforming construction to enable portfolio shareholders to make a statutory claim to claim a tax credit in respect of overseas tax on their dividends. So, on the face of it, the legislation said no tax, but by a conforming construction, the court says yes, you're entitled to your credit. And that was the case in 2014. That was the High Court case in Prudential, 2014. And in particular, it was held that the particular court conforming construction should allow portfolio shareholders to claim a credit for the overseas tax borne by the overseas company at the foreign nominal rate of tax, whatever the tax rate applicable in the overseas country. And because the precise nature of the breach and the remedy gradually emerged from 2006, different claimants made claims and joined the CFC and dividend GLO at different times. And the claimants in the Class 8 claimants were a class of claimants who had made their claims between 2012 and 2014. That's recorded in the head note in the sort of second sentence. And their claims gave rise to particular sort of limitation issues which were considered in this case. And one of those issues was whether Section 320 of the Finance Act 2003 applied to their claims, and they were claiming that they had mistakenly paid tax, again going back to 1973, but were seeking to rely on Section 32(1)(c), and they relied on Jazztel. But a second...
Just so clear, sorry, so it goes back to 1973 and runs forward to what date?
I think 1999.
Yes.
When ACT was abolished.
Yes.
I see, yes.
But in fact, the main issue in which the Jazztel decision was considered by the Chancellor wasn't the Section 320 issue, but it concerned an issue as to whether the test claimant's claims had been ousted by another legislative measure which had been introduced by the Finance Act 2009. That was, I think I described as the regularisation amendment. In Finance Act 2009, Parliament amended the statutory code for seeking a repayment of overpaid corporation tax, so as to make the statutory code the exclusive remedy. And at the same time that it reduced the statutory period for making statutory claims from 6 years to 4 years, and that legislation was not retrospective. It was introduced by the Finance Act 2009, which was enacted in July 2009, and the ousting of the common law claims and the adjustment to the limitation period applied to claims made after the 1st of April 2010. So and that took effect under a new paragraph 51, 6 of the of paragraph of Schedules 18 to the Finance Act 1998. So, prospective legislation so it was originally announced in the 2009 budget, so around April 2009, enacted in the Finance Act 2009 and comes into effect April 1st of April 2010. But the effect of it coming into force on 1st of April 2010 was that a category of claimant lost their rights to make common law claims and one of the arguments they raised as well, when this act came into force, we didn't know we had rights. We didn't know we were able to claim tax credits under the legislation. We didn't know that we had a right that we could recoup money from the revenue till after this act had been enacted, and therefore applying the reasoning in Jazztel, there was hidden retrospectivity in this act, such that it's a breach of the principle of effectiveness. So the dates, if I can just take you briefly through the relevant dates and issues. Paragraph 6 of the judgment, we see that the claims were issued after 31st of March 2010, so after the ouster clause has come into force. And in paragraph 9, the first issue was whether the claimant's common law claims in unjust enrichment and mistake, which were issued after March of 2010, were ousted by the new exclusive regime. There was also Section 320 issue. Does Section 320 of the Finance Act 2004 have effect in relation to claims for restitution of tax paid before and or after its introduction? And if so, the relevant date of introduction from the date from which it took effect, or the date of royal assent. So, I mean, if the ouster clause was effective, then Section 320 sort of fell away. So that explains why the structure of the judgment starts with paragraph 51(6), the ouster. That's on paragraph 10. The Chancellor explains that. Paragraph 51(6) issue took most of the available time in the argument. That which was the bulk of the Class 8 claims were issued in 2012 and 2014. I suppose the prudential claims that were made were all mostly issued before 2010, so they were precluded by the new legislation. Mr. Aronson, paragraph 11, for the taxpayer, submitted his clients had made statutory claims for the recovery of overpaid tax and interest within the time limits in every conceivable form, yet according to the revenue, those claims were insufficient. He said that alert and diligent claimants are being denied an effective remedy, which must be a breach of EU law principle of effectiveness. 12, it's true, submitted Mr. Aronson, that EU case law allows a member state to apply a time limit even where taxpayers fail to make a claim in time because they're not aware of their substantive EU rights under a treaty. See Fantask. The rationale for that line of cases is that legal certainty demands there must be closure for the state. So that was the claimant's position and the revenue's position at paragraph 13. Mr. Hewitt, the revenue, answered these submissions by pointing to the line of cases that demonstrate that a member state may shorten time limits if it gives appropriate notice, even if that means that the claimant can never bring a claim because he did not know about it at the relevant time. The EU law principle of effectiveness gives the claimant the means to make a claim, but it does not require that the claimant must know that he has a claim before it can be taken away by an appropriately notified limitation period. And the revenue was saying that well, you could have had made claims, which would have generated your right to a credit, but if you didn't because you didn't know about that, that's too bad. So the Chancellor sets out the basic statutory regime concerning double tax relief and tax credits. I won't take you through those, but that's from paragraphs 19 to 24. And then paragraph 51 is set out of the Schedule 18 to the Finance Act 98 is set out at paragraph 26 of the judgment on page 255. And paragraph 51.6 towards the bottom of the page makes the statutory claim the exclusive remedy.
I'm sorry, I'm not with you. Which page are we on here?
Page 256. It's
256, sorry.
5108 of the report.
Thank you. Yeah, got it.
Paragraph 26, and that's Schedule 51 as a 51 sub paragraph 6 set out at the bottom of the page there.
Yep.
And that was introduced with effect from 1st of April 2010. The Chancellor then goes through all the cases that we've looked at, including Grundig, Autologic, Fleming, and the Supreme Court decision in FII that preceded the reference on section 320, and also Jazztel at paragraph 72. Onwards. And he turned to deal with paragraph 51.6 at page 70, paragraph 74 on page 287. And part of the argument there was whether the High Court decision in Prudential had been correctly decided. The claimants were saying it hadn't, but Chancellor said yes, it had. So the claimants did have potential rights to make claims. Then he turned to the sort of retrospectivity issue. On page 290, paragraph 85. So here the claimants were saying, well, our claims were taken away from us, they were ousted. Yes, there was a transitional period, but according to the judgment in Jazztel, that's irrelevant because the vice of the legislation is that our rights to reclaim have been taken away with a transitional period that was not utilisable by us because we didn't know we had any the relevant rights. So 85, Mr. Aronson submits that I should follow the decision of in Jazztel, so as to decide that a claimant who does not know that a remedy is available to him cannot have an effective remedy for the purpose of EU law. The 86, the paragraph 51.6 issue is, of course, whether paragraph 51.6 operates so as to oust the claimant's common law claims. In this context, it will only not do so if those common law claims had accrued before paragraph 51.6 was introduced on 1st of April 2010. And the notice that was given of its introduction did not enable claimants to make the appropriate claims for relief during the transitional periods because they did not know that such claims exist. This is what Justice Marcus Smith described as the hidden retrospectivity, which he held was contrary to EU law principle of effectiveness. You will have seen in the judgment. I've considered his reasoning on this point carefully, but I am unable to agree with him. He refers to paragraph 100 sub 6 of Jazztel, where the judge says the real mischief which I consider must be addressed in order to render section 320 compliant with community law is the loss of accrued rights of which their owner is ignorant. That is the hidden retrospectivity of section 320. He then drew the distinction between the Leeds case and he said, although Jazztel and taxpayers in Jazztel's positions have an accrued right to recover overpaid SDRT, they do not know about this right. A transitional provision giving them notice of the introduction of 320 will not give such taxpayers any notice of the claims they have. In my judgment, this is a misunderstanding of the EU law cases and of the EU law principles of effectiveness itself. He then highlights the statement as articulated. Well, he's chosen one of the FII ECJ cases, and the point he makes is the procedural rules that must not be framed in such a way as makes it impossible to claim. The knowledge of the claimant as to the existence of a claim is nothing to the point. And he refers to Lord Neuberger in Fleming. 90 said what these authorities do not say is that the limitation period can only be attenuated when the claimant is shown to have known that he or she had the accrued right in question. That would be contrary to principle. He then picks up other passages in the judge's decision in this case, at paragraph 91. Where the judge is focusing on the point that the transitional period is no good to someone like Jazztel because they're not aware of the effect of the legislation, so that they're not going to be able to take the steps during the transitional period. So that's what stopped the learned judge from thinking that one could read in any kind of form of period of disapplication in the present case, because there was no purpose in doing so, because Jazztel didn't know of his rights. And that's the sort of line of reasoning that the Chancellor disagreed with fundamentally, because he says that, well, that's not what the principle of effectiveness requires. It's concerned with the procedural rules and do they make it impossible.
And the impression I get from Jazztel's skeleton is that there's no longer really any issue about that. It's not contended that knowledge makes all the difference. I'm just wondering why it featured so largely in the judge's judgment. Was he on a bit of a frolic of his own here?
Yes, I think that's a fair description.
Yes.
But we now have two High Court decisions.
Indeed we do, yes.
Saying different,
no, it's just puzzling. I wondered where it was sprung from.
Yes. It didn't figure largely in my learned friend's submissions below. So I think that does provide the answer, but it does illustrate why the judge sort of closed his minds to the issues which have been addressing this morning, as to, well, how do we pick the right period, and can we pick a transitional period, and because the judge just looked at this differently. So we invite you to prefer the reasoning of the Chancellor on that issue, which does sort of take away all the building blocks of the judge's decision. And on the Section 320 issue, this has become sort of academic. So the Chancellor deals with it quite briefly at section paragraphs 122 to 124. And he says, for the reason that the reasoning that he applied on the ouster travels into section 320 as well. And the claimants were saying that, yes, the Leeds City Council case covered the position for tax paid after September 2003, but was saying that the reasoning in the Jazztel decision should mean the same conclusion in this case. And so the judge says that I've already dealt in substance with this issue, which asks whether Section 320 has effect in relation to claims for restitution of tax paid before or after its introduction. He's considering that his reasoning on hidden retrospectivity effectively deals with the point in that case. I've already said that he disagrees with Jazztel when the judge held that the legislature's ability to deprive taxpayers of an existing claim to recover overpaid tax depended on whether those taxpayers knew they had a claim. So he concludes the answer to the third issue is that Section 320 has effect from 22nd July 2004, whether the claim relates to tax paid before or after 8th of September 2003. After a draft of this judgment was provided to the parties, the claimant sought to re-argue this issue by referring to the decisions in FII and both the Supreme Court and the Court of Justice as reasons why the issue should be answered differently, whether or not Jazztel was correctly decided. As Mr. Ewart submitted, however, the claims which were issued in FII CJE 3, which is the decision in FII which I showed you this morning from the Court of Justice, those claims were claims in relation to tax paid more than 6 years before 8th of September 2003, because those were the Aegis claims. It was those claims which had been removed by Section 320 with immediate effect and without a transitional period. So common ground that Aegis type claims are to be Section 320 is disapplied. In this case, the argument about whether Section 320 was effective to remove claims that accrued before the legislation took effect, but in respect of which part of the limitation period, at least 6 months, had still to run when the legislation took effect. Claimants argued that Jazztel meant that Section 320 was not compliant with EU law because of its hidden retrospectivity. It was that argument I've held to be wrong, as it seems to me without it, the decisions in FI do not affect the facts of this case, because, as I say, in these cases, there remained an unexpired part of the limitation period after Section 320 was introduced, which was not the case on the facts in FII. So there is this difference. He doesn't refer to Grundig expressly in his judgment, but I see that Caterpillar, Grundig, FII were all sort of cited to him. So,
Mr. Baldry, can I just ask you about that passage?
Yeah.
When the Chancellor says there remained an unexpired part of the limitation period after Section 320 was introduced, is that in substance your point about that there was in fact some transitional period?
yes, yeah. We call it a transitional period or a prospective period
Yes.
for which people can bring their claims.
Well, against that background, can I just ask you about the middle of paragraph 123? I think I know what the Chancellor is saying, but I just want to be sure what your submission is about it. In the middle of 123, he says, "In my judgment, Section 320 was effective to remove common law claims to restitution in respect of tax paid before Section 320 took effect." Now, in the preceding paragraph, he has said that it took effect on the 8th of September 2003. But I think actually what's being said is that the limitation period the new limitation period of 6 years takes effect on that date. So obviously the tax may have been paid back in 1998, for example.
Yes,
But that's all consistent with your submission, isn't it?
yes. And particularly Grundy made it expressly clear that it doesn't matter if the tax has been paid before.
I mean, is this right that in Fleming, the revenue didn't run your current argument? In this case, the taxpayer only ran Mr. Krasinski's argument once the draft judgment had been provided.
So that's what it looks like, yes.
Yeah.
Well, I haven't taken you to the judge below, but I'll take to it briefly. But in the course of discussions over the course of today, I think really you know what I have to say about it. We have our skeleton. In addition, as I say, that because the hidden retrospectivity was really the linchpin of the learned judge's decision, and that sort of not seriously challenged it, and we say that the Chancellor has provided a very clear reason as to why it's not correct. That sort of leaves open the issue which I'm seeking to run before this court, and that's an issue which is under Fleming and Lord Newberger's principle. It is an issue which is open to raise, and so we would say that the appropriate step for the court to take in this case is to both reverse the learned judge's decision and to hold that in the present case, Section 320 is not incompatible with the principle of effectiveness. There the claims that Jazztel made in 2013 are out of time because Jazztel wasn't aware of its rights, and that the limitation period that was introduced by Section 320 of 6 years, effectively, was a prospective limitation period that Jazztel had adequate time to prepare its claim and submit its claim. And as in Class 8, the Chancellor said that if that case concerned claimants with adequate time to make their claim, if you've got an adequate time to make their claim, the national law prevails, and the disapplication that would arise in the case of Aegis does not fall to be made in the present case. Now, of the niceties of the arguments that we've been addressing today, and Grundig and Fleming don't really sort of come out of the decision of the learned judge. What he clearly did do was equate the subjective knowledge of Jazztel with objective impossibility, and that was the very thing that the Caterpillar case that I took you to says is not the correct approach, and that's where he talks about the real mischief of the provision. Paragraph 100, subparagraph 6.
To be fair, Caterpillar came after the judge's decision below, I think, didn't it?
Caterpillar itself.
Itself,
yes.
But still, you say, but that doesn't make a proposition any better.
No, I think that the Chancellor's point was that it is once you have a time limit, it comes against you whether you know you've got it or not.
Well, that's rather the nature of them. Indeed, that's why one has provisions like Section 32(1)(c) by way of mitigation.
Yeah. And they are one of the largest categories of people to come up against a time limit is the person that doesn't know they've got the right.
Yeah. And the CJEU is always careful to say that the justification for that is really the principle of certainty rather than anything to do with effectiveness.
Yes.
For the existence of time limits in the first place.
Yes, exactly.
Any civilized system has to have a cut-off point.
Yes.
For obvious reasons.
Yes, apart from input tax and VAT.
Well, with odd exceptions, creep through, probably by oversight.
I think that the only point I'd sort of also draw out of the judge's hidden retrospectivity point on page 1156 is that
Sorry, on page...
page 156 of the tab 9.
Yeah.
He draws the contrast between the taxpayer one discovering in 1985 that he or she made a mistaken payment in respect of a tax unlawfully levied. Taxpayer one discovers this on 7th of December 2003 and issues proceedings on the same day. And taxpayer two makes the same discovery of a mistaken payment in 1985 but does so on 9th of September 2003. So they can't, and that's essentially the Aegis case. So we say that the judge's decision was wrong, and the case law has the effect that I've tried to explain this morning. So, unless I can assist you further, that was going to propose to say on section 320.
Yeah. So section 32.
So next it's section 32 1C. And following the judgment of the Supreme Court in the FII Supreme Court case, I think I said earlier that that was the latest FII Supreme Court case, but I've forgotten that there had been yet another. Since
There was one the following year. I mean, last year, wasn't it?
Yes.
I mean, last year. Yes,
They
go do
blur
it.
into
Yes, they
everyone.
all. Yes, they coalesce in a rather alarming fashion.
But after that case, the Revenue have applied to the court to amend their grounds of appeal to argue that Jazztel's claim is time barred under Section 32(1)(c). Our application is called Bundle 324, and it may have just you may have read this, but just the nature of the amendments that we're seeking is on page 27.
I'm sorry, where is it in the core bundle?
Core Bundle tab 3, page 26
Yes.
is the draft amendment.
Oh, yes.
Grounds of appeal.
So it's the new ground 5.
Yes.
So that's on page 27.
Yes. So that's one application that we've made, and we've also made an application for you for us to rely on certain documents which were before the judge, which is relevant to our application, but I was going to come to those in due course. The first point to decide is whether the approach the court should take as to whether the Revenue should have permission.
Yep.
And if permission is granted, then obviously the issue is whether, on the facts of the cases found by the judge, Jazztel discovered, or could with reasonable diligence have discovered, its mistake in making those payments as we've set out in our amended grounds, in light of the new reasoning that's followed from the sort of seismic shift relating to the decision in Witcher Morgan Grenfell. And on the first issue, is it appropriate for permission to be granted? We submitted it. It is for substantially the reasons or similar reasons that were given by the Supreme Court in granting the Revenue permission in FII. So we can go to the decision of the Supreme Court. That's authorities. Bundle 2, tab 8. And there were various other issues in FII, given that the unusual way those proceedings had evolved through a split hearings of questions of principle, together with questions followed by a second set of litigation, followed by a whole series of further appeals concerning liability, and there have been various orders made in the first set concerning this issue, which hadn't been appealed by the Revenue. So there are various issues that raised judicata and issue estoppel and things like that, which don't really arise in this case.
That's a mercy.
But we have a sort of a broader question, which the court deals with from paragraphs 85 onwards, is whether in that case, whether the court should exercise its discretion to allow the Revenue to raise a point which it hadn't raised below. And from the passage from 85 to 99 makes it clear that the Supreme Court were in no doubt about the weighty consequences that would arise from allowing the revenue to raise the new point, in particular concerning Section 32(1)(c at the end of the second stage of litigation, which had been running for many, many years. And the court acknowledged that it would be better if the revenue had reserved their position formally in the courts below, and indeed should have appealed some of the orders which had already been made, which were inconsistent with that. The revenue's changed view on Section 32(1)(c), but ultimately the Supreme Court considered that the matters raised, including the correctness of Deutsche Morgan Grenfell on Section 32(1)(c), were of such significance that if Deutsche Morgan Grenfell were wrongly decided, it would just be wrong to decide the case before them on a basis that was wrong in law. That's their sort of final position at paragraph 99. They fully understood that the claimants had been litigating on one basis for many, many years, but ultimately the court said at 99 that when considering the exercise of discretion, that the nature of the claims, depending as they did on a developing area of law, means that it's important this court address the legal questions which the revenue wished to raise. The size of the claims and their impact on the public purse are also relevant considerations, as it would be wrong to uphold such claims if they are based on an incorrect understanding of the law. As we've said, even if the revenue's challenge to the application of Section 32(1)(c) succeeds, claimants will have claims of substantial value. The legal question is also of great importance to other claimants outside the FII litigation, including claimants in the litigations to which we've referred in paragraphs 5 and 6 above, who also have claims of high value. That includes the stamp taxes litigation. So this is a Supreme Court fully appreciated they're making a major change in the law at a very, very late stage of these proceedings, but it was such an important point of law that they gave great weight to it in giving permission.
Can we just look at these factors for a moment to understand? So in this paragraph, we get reference to developing area of law, where you say that applies to our case.
Yes.
Size of claims. I suppose there are two sorts of size of claim. There's Jazztel's claim. I've forgotten, that's several million, is
it? It's over 1 million, 2 million, 3.
It's less than 5. Yeah, it's about somewhere between 1 and 2.
2, 1, 2, yeah.
Yes, I see.
That's after the bugbear of compound interest.
Which is gone.
Gone, yes.
Post-prudential, that's gone.
So pre-prudential, it would have been very substantially more, presumably.
Yes, that's yes, principal and simple interest.
Yeah, thank you.
Now, on a wider picture, you're presumably concerned with much larger sums if you add together all the great Group Litigation Order claims. But a determination in this case won't necessarily determine all the other Group Litigation claims.
No, I mean the limitation, the answers to the limitation questions should certainly help to resolve those.
it's inherently case-specific, isn't it? You have to look at the particular facts of every case to see what advice they had, and I know it's an objective test, and you may say it will help to that extent.
Oh yes, if in this case Jazztel's claim was discovered or was discoverable in 2000,
yes,
that is a factor that will be taken into account in other claims.
Well,
in terms of what if one taxpayer gets to the stage of a reasonably diligent taxpayer having a claim that's discoverable, then that is part of evidence in another case that.
Is it part of the evidence?
It would be a factor. It wouldn't be determinative, but be a factor.
Would it be? I mean, if it was simply a determination on the facts, I mean, doubtless you could extract some proposition of law which would apply in another case. But if there was simply a determination on the facts that Jazztel could have discovered, would that
you would then
be
have
something in another case?
You would then have. I think we might be sort of leaping a bit ahead of ourselves to work out what the test is. But certainly we were saying that the test of discoverability under Section 32(1)(c), the second limb is what a reasonably diligent claimant, what is discoverable to that reasonably diligent claimant, and certainly our position would be that if one's established that a reasonably diligent taxpayer would have discovered the mistake at a certain point of time, then that would be a factor for taken into account in other cases.
I don't know. I mean, maybe it wouldn't be at all. Alternatively, maybe it would depend on what level of abstraction the judgment were arrived at. If it were tied to Linklater's advice here, it wouldn't seem to bear on any other case. If it were, well, anybody can work out what the law is.
There may be that's a nuance, but the reason why we would say it might well be relevant is that if in this case one goes to the test, is it was a reasonably diligent claimant justified in getting the information, searching for information or issuing a claim, then that is a sort of a more objective test. So obviously, in the present case, one would take into account the fact that Jazztel actually had the advice and it made the claim. But the fact that Jazztel did that would inform the decision about whether the state of the law was such that a reasonably diligent taxpayer in Jazztel's position could also have sought the advice. And we say that the test now is were they in a position that they were justified in seeking this advice.
And one of the problems is that the test, as restated by the Supreme Court, is likely to involve questions of expert evidence about the state of knowledge in the legal
profession,
and no doubt perhaps academically as well, at a particular time. And that may be reflected in the advice that Linklaters happen to give to Jazztel. But in another case, one will be looking much more for expert evidence about the wider picture.
But I think that what one gets from the decisions at the starting point is that it's discoverable. If you pay by a mistake of law, it's discoverable. And the Supreme Court was sort of careful to say, well, we have these unique cases where the answer is essentially not discoverable immediately because the state of the law is such that it just evolves so slowly, particularly the treaty cases, that what were you to do at a very early stage in 1973, when we joined the European community.
We had all these issues in relation to the damages claim.
Yeah,
which was
but
very nice in
FIR. That was the case where they were saying we would need expert evidence, where you've got a situation where either there's been a retrospective change in the law, or what's happened in the sort of FII type litigation, a starting position. Everyone would say this treaty has nothing to do with UK tax law because it's up to the member states, and over a process of many years, a provision, and only through the workings out of the Court of Justice, there comes a point in time where the discoverability is reached. That we are not in our cases, that we are not in that position here. If we're right, and that the Linklaters' advice and the claim constitutes discoverability, then any expert evidence is irrelevant.
I mean, in that respect, I suppose there is an important distinction between this case and FII, because in FII, the Supreme Court was expressly contemplating a further trial. One sees that in paragraph 91. Whereas, as I understand it, you say, do you say that come what may, there would be no further trial. You either win or lose on what is already available.
We say that on what we place our case firmly on what is available, what the findings that have been made. Certainly.
Do you go further and accept that if you don't make out your case on the materials that are available, that's that?
Well, then that would be a discretion. That would be a further factor for the court to take into account as whether it had to be remitted. Oh, I'm sorry. Well, I mean, it's not closed off, but our primary case is to have the case decided. We say that on the basis of the facts that have been found, that this is the clearest case of discoverability. And what the role of expert evidence in the FII case was contemplated in terms of, well, there's another. You can't simply say that the mistake was discovered at a time when somebody else took legal proceedings, because you might be able to show that you could have found it out earlier. There might be expert evidence to see whether it could be, in your particular circumstances, established earlier. So that's 255 of paragraph 255 of FII when they were talking about the remitter in that case.
I mean, I think this is probably out of order, raising the point out of sequence, but there, as you say, it's contemplated that expert evidence could show that you could have known before the date when somebody else made a claim. I mean, here, as I understand it, the HSBC Vidacos claim was made in 2002, but there's no evidence anybody knew about it in 2002, which is rather different, as I understand it, from Deutsche Morgan Grenfell, where Deutsche Morgan Grenfell was aware of the claim almost immediately.
Yes, I mean, the reference, I remember when the reference in HSBC was made. 2007.
December 2007.
Yeah.
But of course, that wasn't the first stage of the proceedings. I think Mr. Justice Marcus Smith says the claim was put into the revenue in 2002, but presumably nobody knew about it in 2002, or at any rate, there's no evidence anybody knew about it in 2002.
But that certainly goes to discoverability. Is the reasonably diligent person justified in making a claim? But we say all that in this case, and the answer's already here because a claim was made.
Do you accept that this issue that's raised by you on new ground is an issue of fact? It's not an issue of law.
No, well, we say it's an issue of law based on the facts based on the facts that have been found.
Well, look how the Supreme Court described it at the beginning of paragraph 255. Court can't determine in the abstract the point in time, etc. It depends on the examination of the evidence.
Well, that's because there was no relevant evidence in that case, but in the present case, we have the evidence which we say the test throws up.
You may be right about that, but I question whether that makes it a question of law. It's still a question of fact, but it may be that you say the question of fact can be determined on the basis of everything the court has before it, so there's no need for anything new. I understand that submission, but conceptually, I just don't see how it can be regarded as a question of law as opposed to fact.
Because one's seeking to consider essentially a legal question about when the test in section 32(1)(c) is satisfied.
Yeah. Well, sure. The question of law is what is the correct interpretation of the test imported by section 32(1)(c), and it's on that point that the Supreme Court has now departed fairly spectacularly from DMG. So that I'm entirely happy to accept that's a proposition of law, but surely once you've got the test of law straight, the rest is pure fact, isn't it?
But if it is a question of fact, it's not a question of fact that we say requires any further.
Well, that's another matter. But analytically, it's a question of fact. I would have thought.
It is another matter, but that may not be free of problems as well, because I think one of the points that Mr. Grudzinski makes in his skeleton, based on case law like Singh and Das in the Court of Appeal, subsequently approved by the Supreme Court in FII, is that shaping the issues at first instance can be important, because the parties then know what evidence they need to call. So to say, well, the judge who wasn't seized of this issue has made all the relevant findings of fact that you need, that may be right. Mr. Grudzinski may be prepared to concede that, but I'm not sure he does concede that at the moment. I think one of the points he makes is, hang on, we might have put the case differently. We might have called different evidence below if we know this was going to be an issue that had to be resolved.
Maybe it's helpful to look at one of the cases that I think touches on this very point, which the court did consider, the Notting Hill case at 1403.
Is that volume 2?
Volume 2 of the Authorities Bundle, tab 8, paragraph 90.
We're still in FII, but you're referring to the description of Notting Hill,
sorry.
paragraph 90.
Oh yes, Notting Hill isn't itself
paragraph
in the bundle.
Yeah.
Paragraph 90.
Thank you.
And over the page, the Supreme Court talks about the sort of spectrum of cases. At one end, where there'd been a full trial involving live evidence, and the new point might have changed the course of the evidence or required factual inquiry, there was likely to be significant prejudice to the opposing party, and the policy arguments in favour of finality would be likely to carry great weight. At the other end, where the point to be taken was a pure point of law which could be argued on the facts as found by the judge, the appeal court was far more likely to permit the point to be taken. So it's really a question of where we fit in within that sort of spectrum, and we would say that if we're right that the Linklater's letter constitutes discovery, Jazztel could never have met their burden of proof of showing that they couldn't have discovered the mistake until less than 6 years before the claim form was issued. So our position is that there would or should have been no extra evidence below or further factual inquiry. So we don't say that there's any of the prejudice which is anticipated by the first end of the spectrum. But we don't sort of need to get into the wider findings of the judge's findings on this issue, because the fact that we need is the fact that the Linklater's letter was sent. You know, that fact, on the basis of the Supreme Court's test in FII, means that Jazztel met the threshold for discoverability. There's no further finding of fact by the judge that we need to rely on or could have been made to contradict that fact. So, as my Lord said, that the issue of law is what does the test mean? And if the test means, as we say it does, this fact is sufficient.
Well, it's obviously a very strong fact in your favour if looked at in isolation, but who knows? I mean, had the order of cases been different, and had the first instance trial for Mr. Justice Markham Smith taken place after, rather than several years before the latest FII case, then one wonders, I mean, first of all, obviously there would then have been a positive issue as to whether 32(1)(c) was satisfied, whereas I understand it was common ground below, in this case, that it was. The issues were different. They went to causation, and really whether the mistake had actually caused the payments to be made. So it was in that context that all the papers we have in these additional bundles came into being. I mean, had the test as now formulated been what had to be satisfied, for all I know, Jazztel might have wanted to adduce wider evidence about the nature of the wider investigation. I mean, the kind of material which Linklaters were relying on to give the indications which they did. Unless it was all done in-house, presumably it was probably a wider circles in which these questions were being debated, and that could be relevant of whether the development of the arguments had reached a stage sufficient to satisfy the new test of law formulated as we now have it. So that's why it seems it's always dangerous to try and apply a new test to facts which were found in relation to a different issue.
But nevertheless, because we do have the facts that are fact,
yes,
then on our interpretation, legal interpretation of the test, I mean, if you are with us, I would need to satisfy you what the legal significance of that test is. But if you are with me on the test, then we would say that this fact is determinative, conclusive.
And we will then have to consider whether that is sufficient, bearing in mind whatever Mr. Grodzinsky is going to say to us about other courses which the matter might have taken had this been a live issue in 2017. But and in principle, if you're going to get permission to run this new point at all, I would have imagined, speaking for myself, it'll really have to be on the basis of the facts found, and you're stuck with those for better or for worse. And you can make of them what you will, but you're not asking for a remitter, and I suspect we'd be pretty reluctant to contemplate that. In the case,
what I was proposing is to not with any assumption that I have permission, take you through the test and explain why what we say it does mean, and then explain why precisely we say that the Linklater's letter must satisfy that test.
You say, in effect, it really speaks for itself once the test has been correctly formulated.
Yes.
Is that, in a nutshell, what your case is on this?
Yeah. And you must be right, Mr. Baldry. I don't think anyone's suggesting we should arrive at a ruling here and now as to whether you should be given permission. So having explained to us why you say you should be given permission, it must make sense for you to go on and advance the arguments, and Mr. Grudzinski will obviously deal with those arguments as well as presumably why you shouldn't be given permission.
Yes, and in the context of that, there is there's also some further documents which Mr. Grudzinski says, well, that's raising new facts, and which we say really isn't.
Can I just think about that for a moment? We have in the judgment already, as I understand it, an account of the particular documents that you like. To some degree, Mr. Grudzinski's files are designed to show a longer time frame where the particular things you like aren't focused on, possibly. In that sense, it's not immediately apparent to me that you're any worse off if we were just looking at the judgment rather than looking at the two files. Mr. Grudzinski, you still reserve your rights on the two files, do you?
Well, just to be clear, the two files are responsive to the one file
Yes.
that Mr. Baldry wants to put in. Our primary position is that neither set of unagreed bundles, neither the revenue single file nor our responsive dual files need to be referred to at all. Our primary position is that there shouldn't be a need to go beyond the facts as found in the judgment. Indeed, the revenue's original application for permission, and what Mr. Baldry says just now, is that he relies upon and only upon the facts found in the judgment. But if that is right, what I ask rhetorically is the point of referring to any of the primary documents in his single file.
And I see that in a sort of way, but the judge sets out fairly fully what the Linklater's material shows.
Yes. He copies, and with no disrespect, he copies and pastes all the relevant parts of the Linklater's advice into the judgment.
Yes. Now then, so in one sense, Mr. Baldry has the material he's relying on in the judgment already.
Yeah.
At the same time, it's sometimes quite nice to see the original documents. You say if we look at the original documents, we better see the two files, which I understand. But it is...
The point is that the revenue have asked you to look at the original documents.
Yes.
This is why they've applied to rely upon unagreed...
Their supplementary bundle.
Yes, and all we've done is to say, if you're going to do that, don't just put into the unagreed bundle the documents that rather suit your case, have a look at the wider timeline. I mean,
so if the choice is between looking at what the judge has said,
yes,
which is pretty much the things that help Mr. Baldry,
yes,
and looking at the two files with the complete picture.
we are content to look at just what the judgment has said. But if the choice is between looking at the judgment and looking at the wider file, it has to be the two files, not the one file.
Yes.
That's our position.
Yeah. Mr. Baldry, as I understood what I saw yesterday, you would be content that we look at the two files rather than the one file if we're looking at anything. I think we're happy to proceed on the basis de bene esse, that we look at the two files, but that's without prejudging whether it's appropriate to limit ourselves to what's in the judgment.
I'm grateful for that indication, and I would say that the point of our bundle is simply to do what we thought would be helpful to the court. If there is a document that's been quoted, let's have a look at the document. If there's a category of documents that have been referred to, such as the payments by protest, let's have them there to see what they were, without sort of seeking to introduce any sort of new fact into the proceedings. Well, can I move on to the Supreme Court's approach to Deutsche Morgan Grenfell? and why they thought the approach in that case was wrong, because it illustrates their sort of line of reasoning as to why they think their new approach was right, and that the key element of the Deutsche Morgan Grenfell decision was encapsulated in Lord Hoffman and Lord Hope's speeches, which they referred to paragraphs 167, the majority, 167, 168 and 169 of DMG, page 376 of the bundle. And this was given in the classic case that we've seen in so many of the authorities we've looked at today, where a long-running legal issue has been the subject of a finally determinative decision. In Deutsche Morgan Grenfell, it was the decision of the European Court of Justice in the Hirsch case, and it was Lord Hoffman's approach at 167, which the Supreme Court took issue with, because his approach was to equate discoverability with the true state of affairs as is declared by the court. They quote his speech at 167. In this case, however, the true state of affairs was not discoverable until the Court of Justice pronounced its judgment. One might make guesses or predictions, especially after the opinion of the Advocate General. This gave DMG sufficient confidence to issue proceedings, but they could not have discovered the truth because the truth did not yet exist. In my opinion, therefore, the mistake was not reasonably discoverable until after the judgment had been delivered. So the discovery of the mistake in your mistaken payment depends on the true state of the law being in existence or coming into existence. And Lord Hope adopted a similar approach at 169 when he says that the issue was one of law which was not capable of being resolved except by litigation until the determination was made the mistake could not have been discovered, and Lord Walker concurred. 170, it was Hirsch that first turned recognition of the possibility of a mistake into knowledge that there had indeed been a mistake. So the approach of the majority was to equate mistake, the discovery of a mistake, with the certainty of the law, because until a court had told you that a charge was unlawful, you didn't know your mistake, and that threw up the various paradoxes which have been bedeviling us all over the last 10 years. But at 173, it was particularly acute in that case because in FII, the test claimants had been able to articulate their mistake in a claim form some 3 years before the Court of Justice had given its decision, which had finally established the truth as Lord Hoffman saw it. So the court, for that sort of reasoning, thought that the majority in Deutsche Morgan Grenfell were wrong, but they went on to approve the reasoning of Lord Brown, and in particular the reliance he'd placed on sort of the parallel treatments within the Limitation Act of fraud and deliberate concealment. so from paragraph 177 onwards, they make the sort of general comments about picking up Lord Hoffman on this concept of the truth being discovered, and saying, well, the courts are actually on the same journey as everybody else. And at 178, they make the point that evidence can show whether a reasonable claimant knew that there was a real possibility of a mistake of being made. And
Just
then
look at how that's put. You're just coming to this. So paragraph 178 ends up with the formulation that we then see recurring through the judgment.
yes, and that sort of comes out of the context. Well, there's the general one. It's possible to investigate how the legal thinking on a particular question develops. And it was Lord Brown in his dissenting judgment in Deutsche Morgan Grenfell that favoured that approach, and his thinking again becomes part of the majority's reasoning in FII. It's that paragraph 180. They refer to Lord Brown, who was seeking to see section 32(1)(c and mistake in the context of other treatments of limitation under section 32(1), in particular the treatment of fraud. So he states that paragraph 165 is quoted, I would hold that as soon as a paying party recognises that a worthwhile claim arises, that he should not, after all, have made the payment, and accordingly is entitled to recover it, or as here, compensation for loss of its use, he has discovered the mistake within the meaning of section 32. And by the same token, I would hold that if he makes any further payments thereafter, they're not to be regarded as payments under a mistake of law. Lord Brown thus challenged the fundamental assumption underlying the approach adopted by the majority in DMG, that discovery within the meaning of section 32(1) means the ascertainment of the truth, and that a mistake of law is therefore only discoverable when the point of law in question has been authoritatively decided by a final court. On the approach which he adopted, a mistake is discovered when the claimant recognises that a worthwhile claim arises.
I mean, I suppose one issue of law that may arise is what does worthwhile mean, considering that the majority has adopted the word worthwhile.
Yeah.
Is it enough that there is a claim for quite a large sum of money, or do you factor in the fact that to pursue the claim, even for quite a large sum of money, you would have to incur a great deal of trouble and expense and opposition?
Yes, and I think we get some guidance on that by the way that there was the two alternative ways that the Supreme Court said the test could be expressed.
Yeah.
One was the worthwhile claim, and the other, which we'll come to, is about whether it's justified in making inquiries, in investigating it. So I think they both sort of inform each other.
Yeah.
I mean, both formulations seem to require a fairly relatively hard-nosed approach to matters of what's cost-effective in the circumstances, what's reasonable, what can, in other words, it's going to require a fairly close investigation of the particular circumstances of the claimant, I would have thought, and their resources and...
Well, we have certain assumptions
Yes.
are fed into that, which assist you with the reasonably diligent taxpayer who wants to pursue his claim. He doesn't have unlimited
and it's
resources.
quite a complex hypothetical world one has to enter, which is a combination of reality and assumptions.
I can see there may be.
And it's by no means easy to work out how it's all going to pan out, but one gets the impression that what the Supreme Court was envisaging was a relatively low threshold. Is that fair to say?
The starting point is that, as they say, the starting point is if ordinarily your mistake is discoverable immediately.
Well, quite, yeah.
Yes, the change from DMG.
It's the polar opposite almost.
Is complete.
It is curious. I haven't quite got my mind around this, but you can make a mistake even though you know it's possible that you might be right, can't you? And yet, so the very thing, the very state of mind that constitutes the mistake can also be discovery of the mistake.
Yeah, well, but in the context of there's a policy of limitation, and whether you have an extended period, that we would say there's nothing illogical about that. It's a different policy decision which informs the reason to give you a right.
If your mistake is not realising that some years down the line a court is going to tell you that you didn't need to make the payment, well, you're not going to discover that immediately by issuing proceedings. You're merely going to discover a possibility that.
The mistake that you're asserting is the mistaken belief that the provision is unlawful, and you can begin to investigate that at a much lower threshold.
Yeah.
One of the fundamental defects, as I understand it, but correct me if I'm wrong, in DMG's reason was that they abandoned the declaratory theory of law, because the law has always been the same, subject to some exceptions where sometimes, in Luxembourg in particular, they do have the power to issue a prospective judgment. But generally speaking, judgments of a court are not, in fact, saying something new. They're saying what the law has been at all material times. Because otherwise, the parties would not be getting justice. When a party goes to court, what they're asserting is, this is the outcome to which I am entitled.
Yes.
Now. And it may be very difficult working out the answer, whether that's right or wrong, and it may take appeals, and different levels of courts may disagree with each other. But ultimately, when the most authoritative court has pronounced on the question, it's not saying this is the law now, it's saying that was the law which governed your set of facts, and therefore you win because you're entitled to win.
Yeah.
Have I understood some of Lord Reed's reasoning correctly?
Yes, that is a correct understanding of my...
It's a little paradoxical, though, because I think Mr. Grudzinski makes the observation in his skeleton that the same might be said of FII, that in a sense it didn't change the law, even though it departed from DMG, because it simply said what the law has been, and so people should have anticipated what they were going to say.
Well, not necessarily should anticipate, but the question is, have you got that earlier stage that you are asserting? It's true, nobody knows what the law will be, but have you got to the stage where you're able to assert
exactly.
that there is a mistake?
Yeah, although it sounds, at first blush, it does sound paradoxical, but actually, in the real world, as Lord Reed and Lord Hodge point out, decisions of courts don't take place in a vacuum. That often there's been quite a long run-up. So there's often been academic commentary. There may even have been obiter dicta from lower courts and tribunals saying, we're not really sure what the Supreme Court has announced is really working here. So often what happens is that people, if they're reasonably advised, and they go to legal conferences and so on, they may already be anticipating that there may be a change in the future. Anyway, you say that in this case, the Supreme Court has announced a new test, which doesn't require certainty, so certainly something well short of certainty.
Yes, we haven't got onto the bit where we're saying where they do give the clues
Yes.
as to what stage of knowledge that you have to arrive, and it's quite. One's got to keep in mind that there are two sort of elements that you need to pay regard to in this test. What's the fact that needs to be discovered?
Yes.
What is equivalent to the knowledge cases? What's the knowledge you need to acquire? That's one part of it. And then what is the degree of the belief that you need to have about that fact in order to stop limitation running? That there's a relationship between those other parts of the Limitation Act dealing with the acquisition of knowledge was picked up by Lord Brown, as he looks at first of all he looks at the fraud, the parallels with the law on fraud at 182 onwards, and that's where he gets the worthwhile claim test, and he notes that there, when you're looking at fraud, the authorities had said that the correct date when the appellant's solicitors had sufficient information in their hands for the purpose of the claim was the date when the appellants were in a position to plead their own case. And as my lord said, at that stage you know you're going to win, but are you in the position to plead a case? So at 186, the court says that they regard it as important for present purposes that the approach adopted in the cases like fraud treats the relevant date for the purposes of commencement of limitation period not as the date when the claimant knows or can establish the truth, but as the date when he can recognise that a worthwhile claim arises. So it's bringing Section 32(1)(c) as it applies to mistake in line with the others. Mistake claims don't suddenly benefit from this completely different approach. So he then takes it on to considering the position of tort, which is important. At 187, Lord Brown also found support for his position in Deutsche Morgan Grenfell in authorities concerned with the interpretation of other provisions of the 1980 Act which postpone the commencement of the limitation period until the claimant knows or could reasonably have known the facts forming the basis of his cause of action. That approach, for example, is applied, for example, for actions for damages in respect of torts causing personal injuries by Section 11 of the 1980 Act. Under Section 11(4), with Section 14, the limitation period generally runs from the date on which the cause of action accrued, or if later, at the date on which the person injured had knowledge that the injury was significant and was attributable to the act or omission relied on, and the knowledge of the identity of the defendant. For these purposes, knowledge is defined as including knowledge which he might reasonably have been expected to acquire. See Section 14(3). The language of these provisions differs from Section 32(1), in that they refer to having knowledge rather than discovering, but that is on its face an insubstantial difference, since discovery ordinarily refers to the acquisition of knowledge, and sections 11, 14 and 32 have the same rationale, namely that the limitation period should only run from the time when the claimant knows or could reasonably have known of the existence of his cause of action. Sections 11 and 14 are expressly concerned with knowledge of the facts forming the cause of action and not with their legal consequences. But the same is true of Section 32(1), even in its application to mistakes of law. as it's explained below, the relevant fact that has to be discovered in that context is the fact that the claimant made a mistake, that being an essential ingredient of his cause of action. A claimant's ignorance of the legal consequences of the facts forming his cause of action is not something with which Section 32(1) is concerned, as Lord Walker made clear in FII Supreme Court 1. That's consistent with the intention of the Law Revision Committee. So that is then what it is that you have to discover. That's the relevant fact. And then...
Sorry, is that the relevant facts that you have to discover?
The fact that the claimant made a mistake.
But the fact that the claimant made a mistake is itself, at this stage, unexplained. I mean, later on, you get the Supreme Court saying, made a mistake in the sense that. Where does it say that?
193. Sense of recognising that a worthwhile claim arises.
Yes. So that suggests that the fact you have to discover is that a worthwhile claim arises.
They are the fact you have to discover is the fact that you need to be able to put in your pleadings.
Well, that may, if you can equate the two, if you can equate discovering some facts with knowing that you have a worthwhile claim, then they're the same.
Yes.
But if worthwhile imports more than knowing some facts, then they're different.
You can see it as two stages. If one's thinking of the mistake being the fact, then one's got to look at what is the relevant state of belief that you have to have concerning that fact in order for time to start running against you. And that it's in that context that you've got to have the relevant belief concerning the unlawfulness so as to justify investigating further. So at that stage, you don't really need to have any sort of particular thought about that you've got a good claim, but you need to be able to just get to the stage of investigating further.
Yeah. I mean, it may be that the ability to plead a proper statement of claim is quite a good test in one sense, because that has to be verified by a statement of truth. And if it's a fraud case, there are also well-known conditions which have to be satisfied before a professional pleader can put his or her name to a claim of fraud. But I mean, so that may be on any footing, that would be sufficient. But there could be an issue, perhaps in non-fraud cases, as to whether something falling slightly short of that might still suffice. If you've got to a stage where there's so obviously a potential cause of action there that it's well worth spending further money on taking further advice, looking to see what the wider world is doing about it, and so forth.
Yes,
but without you yet being in a position to actually plead the case.
Yes, I think there is that distinction that's recognised in paragraph 185, where Lord Brown had referred to the fraud cases.
Yes.
For that purpose, there was that was the facts which amounted to a prima facie case.
But I mean, fraud is, in a sense, it's always a slightly special case, because quite rightly, it's a higher threshold you have to cross before you can properly plead it.
Exactly. And it's noted that that test differs from the test that Lord Brown favoured, and that becomes clear when one looks at the sort of different formulation which the court favoured, which they derived from the Howard and Fawcett's case of cited at paragraph 190, because here they've equated the mistake with the knowledge within the sections dealing with tort cases, and then they look at the point of time, paragraph 190, they're looking at the point of time at which a claimant acquires knowledge for the purpose of sections 11.4 and 14.1 of the 1980 Act. And the majority of the court in AB Ministry of Defence adopt an earlier test approved by the House of Lords relating to the latent damage negligence test. And in Howard and Fawcett's, Lord Nichols of Birkenhead stated that Lord Donaldson and Lymington gave valuable guidance in Alford and Brooks. He noted that knowledge does not mean knowing for certain and beyond the possibility of contradiction. It means knowing with sufficient confidence to justify embarking on the preliminaries to the issue of a writ, such as submitting a claim to the proposed defendant, taking advice, collecting evidence. Suspicion, particularly if it's vague and unsupported, will indeed not be enough. Reasonable belief will normally suffice. In other words, the claimant must know enough for it to be reasonable to begin to investigate further. So that's a significantly different test from the fraud test, as my lord said.
So you would say, in the context of mistake of fact as opposed to mistake of law, where fraud doesn't come into it, that's where you are. And as I understand it, well, maybe not. That you say, well, what you have to know is enough to embark on the preliminaries to it, the issue of a writ for mistake. And in that context, it doesn't matter that you think the defendant hasn't got any money?
Yes, whether they've got funds or not wouldn't affect the fact that you've reached the stage of knowledge of the mistake. And as you see, the Supreme Court come round to sort of summarising their principles, but it's quite so helpful to see the origins of the various principles they summarise, arrive from different branches of the law, and what the Supreme Court has done is to synthesise much more closely the limitation for mistake purposes with the limitation period arising in other branches of the law, and have taken the statements from those other things. So we have 187, the statement that the relevant fact is the fact that the claimant's made a mistake, and then 189 is the passage where they consider more precisely the point in time at which the claimant acquires knowledge. And they cite again at 191 the relevant time being it's sufficient confidence to justify embarking on the preliminaries, rather than the point in time when you can plead a statement of claim.
Like the Yes, that's rather the point I was putting to you about fraud cases being arguably a special category.
Yes.
Yeah.
We're absolutely in the meat of this, obviously. At the same time, we've got to 4:20.
Well,
when would be a convenient moment to break?
I mean, in fact, that passage there showing the two sort of elements of the test is actually everything else follows from that, and everything else clarifies those points. So that is not an inconvenient moment to break.
Fine. Well, in that case, let's do that and start again at 10:30 in the morning.